House and Senate Judiciary committees, and we're continuing testimony with Judge Zone and also Barry Persone. So I think you're on the third item on that.
So one of the things we've also done is, as I mentioned earlier, we try to increase the number of judges we have in a courthouse at the time of jury draw days. So that way, if you have two judges there, if a judge can be taking changes of pleas, if the parties know that there's the availability of that, instead of having to wait to do it and keeping jurors waiting during the day, it increases the potential for resolutions. And finally, we've talked about it, Terry and I have mentioned a number of times today, data. Judges do get data. If a judge wants a specific report that can be generated, they request it, we can get it for them. We look at data constantly to try to identify areas that we can improve upon, or to see what's working right, and to try to make sure that's implemented throughout the state. One of the things that we hear quite a bit about recently is about remote hearings. And wanted to touch base about that for a bit. Remote hearings assist us in the courts. They're not a substitute for people coming to court. We're not going to have criminal jury trials remotely. We're not going to have certain other types of hearings remotely. But there is a place for remote hearings, and they are critical to our ability to move forward. There's disagreements at times, and people have concerns about challenges that we have with regard to the remote hearings. A few years ago, one of the challenges that was identified was it was a little 12-inch box, and you couldn't see, you couldn't hear, things weren't going well. There have been tech improvements since then. The Judiciary has now dedicated internet circuits for more reliability, 47-inch screens versus the prior 12-inch ones. There's modular equipment, which means we don't have just a one piece, so that if something goes wrong in the different modules, we can replace it out, and that will help keep things moving. And there's metal cases that have been added that DOC has the ability to access. There's second remote hearing devices that have been deployed in all but two of the correctional facilities. DOC can use those for individuals when they're, for a number of reasons, one of which I know is sometimes there's mental health screenings as an area that they can be utilized to assist with. There are changes that are going to be going forward with additional improvements to the technology in the court, in the jails, as well as a request I know has been made to try to have minis expanded. A mini is something, it's a device that would let individuals within the jail access remote hearings from within the jail if the main system is potentially being used by another court. One of the challenges I think they have, that the judiciary has had with that, is wiring, to make sure that the wiring works. And I know that our tech people are working with the buildings and grounds to try to figure out the best way that I guess matches with security and such, to be able to improve the wiring there. But that's the direction we're going in. But again, is a remote hearing the end all, and that's the way we're going to do all hearings in all cases? No. People should come to court. There's a need for it in many cases for different reasons, but there's also a need for the remote ability. And the remote ability is something, as I mentioned earlier, you have attorneys who are helping out in conflicts throughout the state. They're not going to be able to be in Chittenden County and in Washington County and Bennington County all the same day if they had to be there in person, but they might be able to do it remotely. There's times where individuals are housed far from the court where their case may be. There might be challenges to get them transported to the hearing, and you might be able to do that remotely. We currently, the initial regional arraignments are done remotely in most of the courts. And that is something that we're aware of challenges that have been expressed there. And we're looking at trying to make sure that the hearings that we are doing remotely are being done in a way that facilitates the interest of justice, and that we address any challenges as they come up. But the reality we face is that being remote in many of these circumstances is necessary. We don't have the availability to have sheriffs transport every day to every court at 1 o'clock for people who may have been held the night before. There's not the availability of transports for that. And we also have regularly scheduled hearings. And so the sheriffs, if they're scheduled for certain hearings one day, and then you have 5 or 6 people get arrested, can they get them there in time? Our understanding is that the Department of State's attorneys and sheriffs, that the sheriffs in every county does not have the bandwidth to be able to do that. So that's something which has presented a challenge for getting some people to court. We're trying to work with the Department of State's attorneys, the Department of Corrections, and the Public Defense, the Defender General's office, to say, okay, what are we doing well? Let's keep doing it. What are we not doing well? Let's change it and do it well. And so those are discussions we're moving forward on. One area that I have recently testified on earlier this week, and I said it, and I joked with Isaac Dano from the Department of Corrections that he could stand up and object when I made the comment, but it's we're aware of the challenges that the Department of Corrections is facing when they do remote hearings. They have staffing challenges. While years ago, case managers at the department, case workers, would help set up hearings and provide paperwork back and forth to the courts and defense attorneys, getting it signed to move things along. That's not happening now. The department does not have the bandwidth for that, and it's not workable under their standard operating procedures. The department has worked with us to try to facilitate remote hearings at a level that it believes it can handle. But the reality is we need more. The ability to have a remote hearing that is scheduled, that is conducted at the time it's supposed to be conducted, and that is predictable, that's helpful to everyone. The attorneys need the ability to make sure that their clients need to have conversations with them confidentially, that there's a location, that's arranged. The attorneys at times need to have something signed. If you have an attorney, and I've used the example of Bennington to the northeast up in Newport, but if you have an attorney who has a potential plea agreement to get signed, and that plea agreement can be a remote hearing to resolve the case and move the case forward, it's difficult for that attorney possibly to drive up. It's not as difficult to email the paperwork to the jail, have a staff member print it off, have it signed, have it scanned and sent back, and have the case go forward without the individual having to leave the jail and bring in the sheriffs for a transport. And so there's something in it for everyone. If the Department of Corrections would be able to have one additional person in each jail who was dedicated to basically being a caseworker type situation where they facilitate remote hearings and they help out in other ways. And then when they're not doing that, they have the ability to help out the department. So I just point that out because that's something that I think some individuals who have been involved in the judicial system for a long time, we do remember when the case managers did those things and it did help. And now it would be helpful again, but that's up to the Department of Corrections.
So on that issue, probably not next week, but the following week, there'll probably be a joint hearing between House Corrections and House Judiciary on remote hearings and transports. And we'll be digging in a little bit deeper with the Department of Corrections as well, and state's attorneys and defenders and people. So
I would like to be very clear that there have been times that the Department of Corrections has said, we are not going to facilitate X. And based on discussions that we have had, they have subsequently said, we will facilitate X. The commissioner and the staff has tried to work with us. And I understand that the areas where they might not be able to be on board with suggestions or requests that we have, their position is that it's staffing and challenges that they're facing there. And I certainly understand that. And I don't view it that they're not trying to work with us. They have stepped up to the plate, and certain times on emergency circumstances, they've been great, and they help us out to facilitate the interest of justice. But we just think that there could be some areas that we all improve on there.
all right, so about 5 more minutes, and we do need to move on to the next couple witnesses. So I think we're
The timing
back
is
at
good. We're on our last slide, and it really just has to do with access to justice, which, because of the public safety access to justice title of the presentation, we wanted to just kind of briefly mention of for awareness of efforts to encourage facilitate access to justice. One is an access resource center that we have that started out to be basically designed to accommodate a walk-in clinic at the Costello Courthouse, but it was set to launch right before COVID when all walk-in activity at the courthouse ended. So with the shift to remote hearing capability that happened during the pandemic, we shifted the focus of the Access Resource Center to become more of a statewide resource that people can take advantage of. Self-represented litigants at any courthouse in the state, they want to connect by phone, by email, by video, whatever. They can to people who are their focus is to help self-represented litigants. navigate the system, whether it's with forms, whether it's with questions whatsoever. So the Access Resource Center has developed in some ways become a very valuable statewide resource that somebody's at a courthouse in Memorial and somebody really needs a lot of help, that you've got 4 people in line and you can't really dedicate the half hour that they need. They can then be transferred to the Access Resource Center, people who can help them one-on-one. So just so people are kind of aware of that aspect or that resource. Then also Vermont Judiciary Commission on Mental Health in the courts, recognizing a great number of people that interact with the court that have mental health issues. This commission is a tri-branch effort, and I know Representative Lalonde, you serve on it, as well as Senator Lyons and Commissioner Demmel, Commissioner Morrison. The Defender General's office has Marshall Polis, his representative, and Tim Lidge DeMont from the state's attorney's office. So it's a tri-branch effort with legislators, judiciary, and executive branch agency personnel who are all involved, who are stakeholders in this issue in general. And that's something that the competency evaluation bill evolved from Senator Lyons being on this commission and hearing all of the issues with competency evaluations, proposed the bill that was enacted. So that's kind of just an example of something that this tri-branch effort has accomplished to date. What they're focusing on now and in the coming year are sequential intercept model workshops that have been held in the Northeast and Northwest. They're scheduled in 2025 for the Southeast, Southwest, and Chittenden, where in that region, all of the different stakeholders, whether it's judiciary, executive branch, or legislative branch, meet to assess what's available and try to collaborate, not duplicate, and come up with an action plan for the best way to kind of address the needs of people, and ideally be able to divert, if it's not somebody, they're better treated not in a court setting, to take advantage of the resources there. So just to make mention for awareness of that aspect. And then lastly, we have a Vermont Judiciary Committee on Artificial Intelligence in the Courts that just was created this past year to try to identify how artificial intelligence can help with processing, can help and actually with access to justice for self-represented litigants. There's in other states, they have chatbots that are connected with their website to help self-represented litigants navigate the forms, navigate commonly asked questions, etc. So we want to look at how we can take advantage of that tool, being mindful of risks, but there's different committees that have to do with actually evidence rules and ethics rules and things like that. But there's also a court operations committee that looks at how can we use it to help self-represented litigants, to help court users better navigate. So I just wanted for kind of awareness, make mention of those bodies as well.
So we'll probably want to go deeper on those last 2 issues at future hearings. Senator Bahalski, if it's quick.
I hope it's quick, but I have 2 hopefully quick questions. So with the current state of things, if nothing were to change, about how long would you expect it to take to clear the backlog?
I don't know what's coming in the future, so I cannot opine to that. I know that there are other people in the room that have opinions on that.
Okay.
I'm looking at Matt Valerio. I say that because he was talking about as we were leaving, but I don't know what's coming in. I know that that will definitely affect our ability.
Okay. So also I fully understand that the 4 new judges are just getting started, even though they were authorized, I think, in July. What do you anticipate being the increase in clearance capacity with bringing these 4 judges in?
I can't anticipate it as we're going to see it in this docket or that docket for sure.
Okay.
But what we're looking for is something well over 105%.
Yes.
Our goal is as high as we can get. If you look at the clearance rates on a monthly basis, sometimes it's 150%, sometimes it's 160. So would I like to see 150% in every court, in every docket? Absolutely. That's not going to happen. So we would like to see it definitely increase from where it is now at a number of points higher.
Okay.
And we importantly like to see more cases meeting the goals for disposition guidelines. But before we go, we're going to go to state's attorneys, but I just want to flag a few issues that we didn't get a chance to discuss, but we will hopefully be bringing various folks back in. Work crew, which you mentioned, we're definitely going to have further discussions and probably a bill related to that. Also, whether there are cases in certain areas like driving with license suspended that are over a certain age, should those be dismissed? Rather not have the legislature do that, but we're going to consider something like that. And definitely need to look a little bit further at competency. Individuals who are found to be incompetent to stand trial and are cycling through the system. And either my understanding, either Senate or House committee will be looking at those things. Just want to flag those things that those are issues that we hope to get to. But for now, we'll jump to the state's attorneys.
Great. Thank you very much.
Thank you.
Thank you.
Try to be as quick as possible. And I'm going to share my screen. Tim Leaders Dumont, Executive Director, Department of State's Attorneys and Sheriffs. And with me is the state's attorney who has been mentioned on a number of occasions this morning, Ian Sullivan from Rutland County. All right. Don't worry. You'll have these slides, but we're not going through.
You're not going to read them?
I often leave it. I leave a digital trail wherever I go of information that I hope you find useful. And that's what happens when you invite attorneys to a hearing. So yes, with me is State's Attorney from Rutland County. And you're looking at the data analytics team for the Department of State's Attorneys and Sheriffs. And it's just an acknowledgement. We don't have data professionals in our department, but we have people that are experienced with the cases that we are working with, and then we extract data from our partners at the judiciary. And I want to give a specific public shout out to the judiciary's data team, which sends us the data, which then we analyze for caseload analysis, et cetera. This morning, you'll have these definitions. Just as a reminder, Vermont has a different definition of felony and misdemeanor than most other states. In Vermont, a felony, a crime punishable by 2 or more years, and misdemeanor by less than 2 years. Many other states have a 1-year marker for the felony. As we talked about, the docket is often referred to as a case. Could include multiple counts, which are sometimes also called charges. But as noted, 11 count information is what we would refer in Vermont to how we charge things. Most things in Vermont are charged by information, which is basically an affidavit accompanying an information that we sign instead of a grand jury. We can do grand juries, but they're exceedingly rare. There was one that occurred recently in Lamoille County. We talked about clearance rates briefly, but it's the number you file in, the number you get out. So if you file 100, you get rid of 100 by disposition. That's a 100% clearance rate. You'll see on the left here the dispositional guidelines, which helps set the barometer for what is backlog on the left there. And here's my favorite new AO, administrative order from the Supreme Court. That they recently published at the end of December. And I highlighted some pieces here for you to look at later, but basically there's the administrative order 5 and there's administrative directive 24. Those two administrative documents help the courts set priorities for what gets priority in terms of case time in the courtrooms. I highlighted my favorite parts of this, but basically AO5 is entirely discretionary. The trial court has the discretion to determine in each case. And there's an acknowledgement at the end of this past year that the timeframes are not essentially realistic in the world that we're living in today. In fact, the time periods are often confusing in that they conflict with dispositional guidelines. All this to say, we're all trying our best. You stole my stool line, but the 3 legs of the stool are all trying their best. And we really appreciated this acknowledgement of the reality that despite our best efforts, we are not meeting the backlog goals that I think we strive for. And that the last one I meant to mention, the timeframes are discretionary. However, they do not bind the trial courts or entitle defendants to dismissal for non-compliance with those trial dispositional things. Basically, we can't dismiss cases just because the court system cannot handle what we're putting in there as a result. We shouldn't have that be a rule. Because it would cause a lot of societal harm, in our opinion. Now I'll hand it off to the State's Attorney Sullivan.
And I'll just make an observation that there was a report of a joint subcommittee of the Criminal Rules Advisory Committee and Criminal Justice Oversight Committee on speedy trial issues to the Vermont Supreme Court. Post Odyssey, the court's, I'm still saying new, but it's actually a couple of years old at this point, new case management system. The richness of data that can be extracted from the judiciary is so much greater than what we experienced in the past. But because the system is relatively new, we kind of have 2 sets of data that we are looking at for speedy trial disposition, one that is newer and very rich, and one that is older and that isn't quite as granular in terms of the type of data. So while that speedy trial subcommittee's work, I think, was very helpful for those people working in the system, kind of grapple with how long it is taking certain case types to get to disposition, there's probably more that can be done once the new data set expands over time, especially in the area of super complex cases, your homicides, your sexual assaults, your kidnappings that involve really a wide set of evidence to grapple with in order to bring the case either to trial or to negotiated disposition. We are going to send out this slide deck. There's a lot of numbers on it. What we are looking at here is a statewide data poll back in December of 2023. And this really covers our world as the Department of State's attorneys in terms of what we're dealing with: felonies, misdemeanors, fish and wildlife, civil suspension, then all the juvenile dockets, delinquencies, youthful offenders, and then children in need of services, A through B. Closer to A you are, the more severe the situation the child was in. Then we have a few other areas that we work on that are not necessarily huge numbers, but civil miscellaneous, which tend to be extradition matters to other jurisdictions. Those ebb and flow. Kind of just depends on when people are in Vermont and when they have an interaction with law enforcement. JBA are Judicial Bureau Appeals. So while there are a lot of Judicial Bureau cases, there aren't a ton of appeals from the decisions of the Judicial Bureau. State's attorneys are empowered to work on ordinance prosecutions. You can see that back in December of 2023, that was extraordinarily rare, only 8 across the entire state. And PCRs are post-conviction relief matters. The statutory jurisdiction for those are people who are in custody under sentence. The decisional law kind of expands that beyond just those words, but they are potentially very intensive pieces of litigation. Anytime we're looking at data sets, the window of time we're looking at and the scope of what we're pulling in really matters. What we are looking at here is a point in time, December 10th, 2023, and with all case statuses. So that will include active and inactive cases. And at the time, 26,119 pending cases. We can jump to the next slide, a data poll on December 10th of 2024 to try to give you guys a look, essentially 1 year later. And the bottom line number on the screen, 23,134 pending cases, does show that there has been movement and downward movement in the overall pending cases across the state in all of the case types that we as state's attorneys and our deputies work on. I'll just note that in the December 2023 data set, we did not include extreme risk protection order cases. We did in December of 2024. There were only 3 in December of 2024. So those cases are urgent. They're very time intensive because there is an extreme threat of suicidal or homicidal violence. So it's important that we move quickly and move intensely on those cases, but they are not a huge number of cases. So there's just that one category difference between data sets. And the next slide.
Before you go on,
Sure, yes.
Can you say why, like, I'm curious
Sure.
why you picked December 10th?
I've
like
got to
in
pick a
December.
number. Yeah.
And but
I'd be
in
happy to talk
general,
about that. I mean, just briefly, it is before the holiday season.
right, well, it's in the middle,
Yeah,
sort
it's
of,
before, yeah, exactly. It's before the end of the year.
right?
And we often, it's right as we're sort of getting to our end of year stuff. In January, all of this happens. There's a ton of reports. And so we
Well,
thought
this
it's a
makes
good end of year opportunity to sort of do a check-in. And we've only done it for a year now.
Okay,
And the reason we didn't do it, I think, at January 1, et cetera, is because there's just so much activity. It gives us very little time to analyze. Last year, we had a meeting with yourself and Representative Lalonde about our caseloads. It was very close to December 10th. That's why we pulled it on December
okay,
10th.
it was my
Yeah.
son's due date, but,
Oh, okay.
but I'm wondering.
Well, that's why then.
Right, but I'm wondering if, like, if we looked at June 10th, would
Sure.
things look very different than December?
So-
Like, 'cause, like, sometimes,
Yes.
like, I know the homeless count is
Sure.
one,
So I can
Yeah.
kind of answer that question, and that answer would really be based on filing data. We
Yeah.
tend to see a cyclical filing data trend where the summer, warmer months tend to have a higher number of incoming cases than the winter.
Okay. So
So
opposite
possibly,
of other types of services, which is interesting, right? So, okay.
yeah. And admittedly, summer is the time when attorneys, judges take vacations, so fewer trials happen. So the disposition can tend to be slower.
Thank you.
too.
Good question, though. A pretty random number, other than it was close to the end of the year.
Yeah, and as Tim said, this is the analytics team. I have a very full-time job. The rest of the time, ideally, I would do this monthly. For Rutland County, I bug the judiciary's data team for data sets for us because I incorporate data pretty heavily into our case management and think it's really helpful. But to do a statewide analysis, it probably is 3 or 4 hours of my time, and that
Thank you.
can be a challenge to carve out.
Thank you for that. And, Representative Oliver.
While we're on the subject, and I should know the answer, but I don't, so I figured it's a good time to ask. When law enforcement sends you a case, at what point does it start to actually have a record? Suppose you decide not to prosecute. Is there any data stored on that? Even if it's complete, it has all the elements fulfilled, the whole 9 yards.
We can go over the timeline of a case.
Yeah,
But I mean,
so yes,
if
the answer
you
is yes,
decide I'm
but
not
not
gonna-
in this data set. This data set is coming from the judiciary, so if a prosecutor elects not to file, there will never be, unless I'm really missing something, there will never be a judicial record of that in the criminal docket. If, there's a wrongful prosecution.
I'm just looking
civil
at
suit.
your record.
So our case management system is no longer supported by the company that provides it. We are in the process of getting a new case management system that hopefully will give us a much better way of internally managing data and producing reports on things like that. But our current case management system, if entered into that system, there would be a record of a declined prosecution. I'm well aware that there are times that a charging decision can happen between a police officer and a prosecutor talking about a case at 3 a.m. Yeah, and in that case, if the prosecutor elects not to file a charge, the officer might not send the case for a formal declaration letter, and then that stat would not.
I'm just wondering if we're missing like a bulk of something that's like, well, we don't have time to even do these or.
Sure, I mean, I tend to think of this as an inverse pyramid at the top, kind of citizen interactions where they've called the police, things where the police officers believe there's probable cause for prosecution, actually filed cases, and actually filed cases is what judiciary data would capture. Thank you.
Senator Bahalski.
Thank you. The 3 a.m. conversation between a prosecutor and a police officer, are you referring to sort of the pre-charge diversion type cases?
Oh, sure. Yeah, it could be that. It could also be an instance where one that is immediately coming to mind from my personal experience is an instance where there was an act of violence in self-defense that I believed was justifiable and while there might be probable cause to file the charge, the defense was so strong that I did not believe it would be just to proceed. So that person not sending to a pre-charge diversion program, I believe no crime had been committed.
Okay. Thanks.
Sure. So this, I think, is where things can actually get interesting. And I did an Excel abstract art to cover a comparison. So red, making progress towards decreasing caseloads, green, showing growth in caseloads. And the important caveat I'll give is these are 2 points in time from December of 2023 to December of 2024. So So fortunately, there's a lot of red. That's a good thing. That's a great thing. That means we're making progress in a lot of categories. But I'll observe some counties that had already made a ton of progress on their backlog. They were at such a good starting point that there was less opportunity to make progress. Kind of specifically Washington and Windsor County They had done a ton of work on their backlog before our December 2023 data drop. And the very bottom line is a percentage decrease. Now, there are some areas where the percentage decrease is pretty pronounced. In the juvenile delinquency category, 21 and change percent decrease, and in the CHINS B, a 40% and change. I know, I apologize, it's small. We will definitely be sending
You can
this out.
zoom in as much as you like.
Yes,
right?
yes. But those are smaller relative caseload numbers. So for example, we do see kind of the fallacy of small numbers showing up in that. For example, in Wyndham, they saw a 112 case decrease in their juvenile delinquencies, but in 2023, they only had 141 juvenile delinquencies. So they can't possibly repeat 112 cases, right, to somehow be at negative numbers. That's not possible. The areas where we have the largest number of cases, so the most stable data sets, are going to be the felonies and misdemeanors. And there we saw just shy of a 6% decrease in felony numbers and a roughly 8.75% decrease in the overall number of misdemeanors from those 2 points in time. So single digit progress in reducing the backlog, in reducing the overall caseload. That's 1 year. And while that is progress, I suspect every community that every one of us represents expects that the system will deliver timely justice, and single digit changes are probably not enough to get to timely justice for all of our communities.
So just a question on that. So my understanding of Chittenden County, it looks much more positive there and Franklin County as well, because both of those counties, at least the court reported data that I've seen, had below 100% clearance rates. So
Important
how does that
distinction is calendar
reconcile?
year, fiscal
Yes.
year. We, again, the crack data team here, but we use the calendar year essentially. And the judiciary's data that you just saw was fiscal year.
So,
And the
so
other
no, wasn't that data, it was different data that
Oh,
that I've seen that actually has like a 12-month rolling
Oh,
average,
okay.
or,
Sure.
and it's that rolling average that I've seen
And
is
so-
below 100%. And that's,
We will have a slide later on that summarizes each month's, in another piece of abstract art, each month's clearance rate data. And one of the, I think, interesting things about clearance rate data is that, you know, if your monthly average is, say, you file 100 cases, and in July, you resolve 200 dockets, you would expect that is a really good month on resolutions. But if in July you just have, you know, whatever, a crime spree that causes 205 filings, you've got a negative clearance rate there. So clearance rate and gross numbers for clearances can sometimes have a little bit of distortion relative to each other as we think about the data. And that's one of the reasons I would encourage people to think that there is no single yardstick to measure progress, but that we really have to look at a number of different measurement tools to get a complete and holistic sense of what's going on in our criminal justice system.
so Representative Harvey and then Representative Goodell.
Thank you, Chair. Just to be totally clear, in terms of the distinction between calendar year versus the fiscal year data, we still feel that this is very representative of the current landscape of crime. Like if we rerun your numbers
sure.
using fiscal year data, we're not expecting a
So
dramatic shift in.
we are working
numbers.
off of the
Same data.
judiciary's data, so
Right.
I would expect it to be in lockstep.
Great, I just want to make sure.
Yeah.
Yeah, good.
Yeah, different window, but same underlying data set.
Ian, you kind of answered my question, but I'm just curious. So as we're trying to assess the health of the judiciary, what other factors should we be looking at beyond clearance rate and backlog? And in fact, I'm thinking to myself, I don't even really know, when does a case become a backlog case? Like how long does it need to pend? All these things. Are there other factors or data points that we should be considering when we're trying to assess the health?
Sure. So I think age of cases matters a lot, the volume of filing, and this one is a little less tangible. Are people getting trials when the case is ready for trial? No matter who somebody is in the system, community member, criminal defendant, victim of crime, they really deserve their day in court so that, right, in our democracy, justice happens in front of a jury, right? The government either has to put up or shut up. And if it is taking such a long time that nobody feels like they are getting their day in court on a timely basis, the efficacy of having that day in court, in my mind, drops off pretty significantly.
So the age issue is time to disposition essentially, that,
So I'll add a caveat. So yes, but, right, lawyers love saying that, but, yes, but I think the active time to disposition is probably the more helpful way to think about that. The reason I say that is there are a number of reasons that a case might go inactive. A person could absent themselves from the court process for a period of time, right? They could go on warrant status. And saying, hey, this person was absconded for a year, 2 years. They are perhaps differently situated than a person who has been waiting for their day in court, showing up, asking for their trial month after month.
so are we able to distinguish the pending from the active cases for time of disposition?
So I know that in the speedy trial joint committee, we did some work on that. And that is one of the reasons I say that the data set is definitely still growing. On some of our more serious cases that we would expect to take a long time, the window of time we had to look at was perhaps too small to really tell on those cases, on your murders, your sexual assaults, your kidnappings, kind of the meaningful active day to disposition. On some of the cases that we would expect a speedier disposition, a retail theft of a 6-pack, those cases that should be getting done in 6 months or so, we can see that. And there's a much higher number of those cases in the system to look at. So you're not looking at a relatively small number of cases. And I am thinking back several months now, I cannot remember if that data made it into the final report. I cannot remember off the top of my head if that made it into the final report.
Representative Harvey.
Thank you very much, Chair. Tim, this is actually going back to a comment that you made earlier. I just, before we go too far into the testimony, I just want to make sure that I fully understand. You made a comment that, we shouldn't be dismissing cases because of potential burden to the system. I just want to make crystal clear for this group and for anyone that's listening to this testimony, we aren't currently seeing that, are we? Cases being dismissed because of the potential burden to the judicial system.
So the comment is from the Administrative Order 5, which noted a case that had made the comment that non-compliance with the dispositional guidelines, basically saying you should get rid of your misdemeanor right for 130 days. Non-compliance with that should not result in an automatic dismissal of the case.
Right,
That was
we
the
aren't
comment.
seeing that.
We are occasionally seeing.
We are occasionally. Okay, interesting.
There are dismissals that are taking place due to the staleness of the case.
And that might really happen in two ways. Either one, as an act of prosecutorial discretion, the prosecutor elects to dismiss a charge, or two, there is a motion filed, a Rule 48 motion that has a complex set of factors based on State v. Save, that ultimately allows the judicial officer to make a case-specific, fact-specific determination about that case.
Thank you.
And we can touch more on that probably at a later hearing date about what's happening with some of that. The next one is, we can blast through this one pretty quickly because you heard from Judge Zone on these numbers too.
Yeah, so at the very beginning of the slide deck, you will see the dispositional guidelines for under disposition, near over disposition guidelines, and NA cases. As I mentioned earlier, the window of time and the scope matters a lot when we're talking about data. So this is derived from the judiciary's monthly backlog snapshots that come out roughly on the first of every month, but are targeted at the first of every month. And so this is a slightly narrower scope than the slides we shared earlier. And so this covers the calendar year of 2024. And with this narrowed scope, starting the year at 14,984 and ending the year at 14,015 cases. You can see
This is criminal only.
criminal only, yes, thank you. You can see relative stability across the year in the number of cases in the over disposition back category. A dip at one point in in late spring, but then by the end of the year, back up in the neighborhood of 6,300 cases in the over disposition guidelines category. But an overall, using this data set, reduction of roughly 6 3/4%.
So just a time check. Yep, about 5 more minutes we need to turn, Matt Valerio.
Well, boy, I'll start talking faster.
So, well, you know,
Well, maybe if we can get through as many of these as possible, and if it's okay with you, Mr. Chair, we will happily come back and answer any questions.
Yeah, we'll individually find spaces in our committees to, because we are gonna need to have more information to understand how to support whatever you're requiring.
This will be
for
sent
different
to Nate at the
So
end.
this is a graphical representation of the total pending cases from the monthly backlog snapshot. It's just a picture rather than numbers. The next two
We'll go
slides.
straight to this year.
Okay, yes. So this slide captures our pending homicide dockets as of December 10th, 2024. In querying any data set, how you do it matters. So this data set includes any literal charge of either manslaughter or murder. That means it will sweep in attempts and conspiracies along with the completed murder. So 96 is the number. Here you can see the year of filing. So not necessarily when the murder or manslaughter was alleged to have been committed, but the year in which it was filed. Probably all of us are well aware that sometimes it takes a while to solve these cases. This does not capture investigations, but yet unsolved murders either.
Could we get that, slide in distinguishing attempts?
We will try, but again, you're
Yeah.
looking at the data team. We'll try.
Yes, I believe that would be possible.
It's dependent. We literally are searching an Excel sheet, and so we'll have to sort it. I think we could probably do that. But
Yeah, I believe that's possible.
Okay, so this one, we're not gonna touch on too much other than, Senator Lehowski I popped this in when you were talking earlier, the repeat offender conversation. So just at the bottom there, this is an interesting slide in that I've removed the names of the defendants on the left side of the screen. Over on the right, you see the total number of pendings for each individual. So each of the rows is an individual. So we can see the person with the highest number of pendings was 74. But there's a number in the 20s. And as a sort of takeaway number, there was 150 people with 10 or more dockets representing 2,100 open dockets. So, relatively small group of people that represent thousands of dockets. And then this will also be in your slides, but on the next, here we go, repeat offender. Also, as of this date and point, this is an interesting slide we've repeated for the last few months. Number of people on the left, number of open dockets relating to that number of people, representing total number of dockets. So that look at the very bottom of the screen, 667 people with 5 or more open dockets representing 5,307 dockets. Meaning, again, it's just, there is hundreds of people representing thousands of dockets or cases, as sort of a takeaway, that we talked about a bit last year when we were coming up with the 5 or more for the pretrial, supervision program that's in a pilot up in Orleans right now. I'll also just mention, just because our labor relations manager is likely watching this hearing, we have 300 to 400 cases per attorney in our department, about 600 cases per victim advocate. The victim advocates often work with more victims associated with each case, meaning one case could have 5, 10 victims. And there's a number of reports that this is a snapshot, so it doesn't include the flow through. So prosecutors are clearly handling more than 400 cases per year, which is not in the best practices, to say the very least, according to a number of reports, best practices of societies across the country. And that's just something we've talked about the last couple of years. So our workloads are very high, and we'll talk about resources on a different day.
So I think we do have to move on.
Okay.
And I apologize that, things always take longer, than we expect. But we will look at this information. We're going to have you in because we are going to want to understand how to support, requests for resources, in the next budget. And so, probably in the next couple of weeks, we'll have you in at least, Tim, and hopefully Ian can join by Zoom. We'll try to find a time that he can join. So I apologize that we
Thank you.
Thank you.
Thank you for that.
Thank you. So, everyone, go ahead. It's all very important information. And we definitely want to get it all, but
No,
we'll make sure that we have you back.
We cede the floor to Mr. Valerio.
Certain benefits to going last, and one of them is not having enough, but one of the downsides is not having enough time.
Cleanup.
Yeah, well, it's one of the things I've come to.
Well, you
know.
have until noon. So, I think I can give you 2 minutes less than what I understood that I would need. So pretty close.
Well, yeah, assuming I get everything up.
Oh, yeah, there's the technology, the extra 10 minutes for technology fixes.
Somebody sent me a link, I hope.
Nate, did you send, Matt Valerio a link?
Yes, right now.
Did you get the link? Sorry. I missed it.
Yeah, I got the link. I am now attempting to see.
You're all set.
Okay. I did just attempt to share the screen.
So is, Matt the co-host?
Yep.
Yeah, can you go over to Zoom? Yeah, I was there.
Is this how remote hearings work, by the way?
Yes.
That's your full screen, not
We
just
hope
a slideshow, so you're all set. Perfect.
Okay. By the way, this is exactly how remote hearings tend to work. I condensed, state's attorney had a lot of slides. Court had a lot of slides. I don't have a lot of slides. But what I tried to do is condense it into something that makes the big points. All right. We do everything on a fiscal year basis, so it's always July 1st to the, June 30th. We are a couple of years ahead of the state's attorneys regarding our case management system, so I have data from our system that is that I think is reliable based on our fiscal year calculations. And by the way, I am Matt Larry, I'm the Defender General, for anybody who doesn't know. I might have been a couple of new people, but not too many. In any event, the criminal backlog for the first six, we track it in a couple of different ways, but I took a snapshot from June of 24 until December. And while overall you're getting a little blockage at the bottom there, at the beginning of the if you look in June, we had a 14,164. This is from court data, by the way. Backlog, and then at the end, come December, we were at 13,826. So you see a bit of decline, but you're talking about 300 cases.
Are those active cases, pending cases?
All active.
Okay.
And those are ones that are all past disposition guidelines.
Okay.
What you see is a incremental progress being made on the backlog during that period of time. However, if you look at the counties, I highlighted in yellow some of the counties where if you kind of split them, you've got Addison actually saw an increase in the backlog. Franklin saw an increase in the backlog. Grand Isle, not that big a deal. It's 3 cases. Orange County, an increase. Washington, but these ones, Washington, Wyndham, Windsor, all increases in the backlog. So while half the state is reducing the backlog at some rate, the other half of the state is not. Some is reducing it by small amounts when you compare like June to December, and others kind of go up and down. If you kind of track it, this is what we saw during this period of time, where we saw a decrease in the backlog under 13.8, then it started to creep up during the summer, which, by the way, and I don't know if any of you remember this from the last time I was here doing this, this is what you see every year. You start to hit the summer months and that backlog and the caseload starts to increase. You hit the cold weather, it starts to decrease a little bit. But if you look at it as a whole, and I had our spreadsheet basically give us an average, we're effectively flat. That little red line that goes across, yeah, we're making a little teeny bit of progress, but we aren't making very much progress.
Before you go, I just want to confirm. So your definition of what is in the backlog are cases that haven't met the disposition timeline?
I'm using the court's measure. Yes.
Okay, so that's all right.
We're talking about the exact same data.
Okay.
Because I pulled all of this data is from data that I got from the courts that they send me monthly. So I keep track of it on a county by county basis. And this is showing it aggregated for the entire state. This is
has a question.
Yes.
Yeah, so I'm wondering if the summer increase in clearance versus the winter decrease, is that due to fewer cases?
It's not increase in clearance, it's increase in backlog.
Increase in backlog, okay.
When it goes down, then you see,
Okay, so what my question is do you see more cases coming in the summer and a sort of flat rate of clearance and less coming in the winter? Or is it actually that our attorneys are less productive in the summer, or is it?
No, it's increasing cases.
Okay, so there's more cases coming in the
Yeah,
summer, which is.
More cases are joining the backlog.
Okay.
As we go through those months. This is not unusual, by the way. The court backlog is not something new. The size of the backlog is what's new. We've always had a backlog. One of the running things that we've always discussed within the public defense system is, for example, Rutland is one that we always discussed. Rutland traditionally always had 1,000 case backlog. Always. We were always really happy when it dipped under 1,000. That was Yahoo, but typically it was always around 1,000. Then they'd some more resources would go in for a period of time. You beat it back to 900, and then the resources would go away and go back to 1,000. This, which you can't see on the screen, the last time I did this, I did the same presentation in December to kind of show up my troops where where they were in their particular counties. But this breaks it down by felonies, and this is, actually added cases, for, the last, fiscal year. All right, that would be fiscal year 24. Backlog in and of itself is not the total measure of what the issue is in the system, because backlog is only those that are over disposition. What is following the backlog, is this. We saw an increase in felony cases in fiscal year 24. Not huge, 1.2 in charges increase and 1.4 in cases. When we talk about cases versus charges, cases are people. Charges are counts, charges, right? So we saw an increase of 1.4% in felonies. In misdemeanors, we saw an increase in 3.4% in cases, 4.6% in charges. Here's the one, I made it all red so that even if you can't see anything else, we saw almost a 60% increase in other cases, which are primarily probation violations. And a 47% increase in probation violations, the charges related to that. So total, we saw over a 7% increase in added caseload, going forward. These are, broken down. If you see on inside, there's another, the screen I was using before was literally the size of that wall, so you could see it. But in any event, this is all broken down by counties, like you'd have the counties over on this side. And I highlighted the ones that seem to be more, bigger increases. And so you're talking about like Chittenden County and again, the Washington, Windsor, Wyndham area. Those are going down the bottom. You see small increases, but the bottom line is we're following up a backlog that is reducing, at a single digit rate, 2-3%, with 7% overall increases in clients and charges. I even have data up through the first quarter of fiscal year 25 has been scrubbed. So these are broken down by the counties as well. Bennington County has seen a massive increase in both cases and charges. We also, if you see this whole bottom part with Orleans, Rutland, Washington, Wyndham, Windsor, all have seen increases. The good thing is that Chittenden, as a big county, has seen a 7.8% decrease. But overall, we are again seeing for the first quarter, and I guess you can see it, we see almost a 6% increase in cases, which are people, with a 4.4% increase in charges in the first quarter when you compare quarter to quarter, fiscal year 24 to fiscal year 25, right? So backlog is one thing, added caseload is a whole other thing. Bottom line is these cases haven't made the backlog yet, but they're coming. And whatever's in front of them that is sort of clogging the pipe, has to get resolved, or these guys are going to end up in exactly the same situation, which is a backlog. I'm glad that the slide that State's Attorney showed corroborated what I saw when it comes to family cases. There's some good news and one piece of really unfortunate news. The good news is in fiscal year 24, we saw a reduction in Chins A, Chins B, Chins C, Chins D, delinquencies. All of those went down by healthy amounts. However, you saw a 40% increase in termination of parental rights cases.
Yeah.
During that same period of time.
40%.
Yeah. And when I see that, over the last 24 years, what I feel is that somebody's made a policy decision about bringing those cases. It's one thing if you get 3%, 5%, small amounts that'll fluctuate. When you see 40%, somebody's making a decision. And I don't know what that decision is. I was stunned by the number. It may also be, and this is fiscal year 24 in total over fiscal year 23. All right, we're in 25 now. So that kind of increase says somebody's making a decision.
So where would such a decision be? In the state's attorneys? Is
No.
it,
No, I'm sorry,
general?
I'm gonna have to address this,
No.
because you notice it wasn't in our data, because we don't do the TPR.
Right.
Right, okay, so not that.
This is-
so-
Put
but-
that-
but
no,
is
this is
it
not
the
their,
Attorney General that decides that, or
No,
is
the
it
chin stuff was the same thing.
DCF.
We're talking about the same thing. TPRs, however, that's Department of Children and
The
Families
DCF.
makes that
Shoot, the
decision, the
advocate.
Attorney General's office. There might be some change in leadership at DCF. Sometimes I see there's a new training that happens, and all of a sudden now training has filtered out to the district offices, and they're making decisions about what cases need to go to TPR as opposed to try to find permanency by extending the chins cases and doing administrative reviews that put more work into trying to reunify families. That's just a big number. I don't know the answer. And I don't know that anybody would actually tell me the answer. But it's concerning. Because we do those. And when you're doing a TPR and you're doing it right, this is the quote unquote murder case of the juvenile docket. You get serious experienced lawyers spending an awful lot of time, taking up a lot of court time. And when it gets to those cases have priority over the criminal docket. They have priority over the civil docket. So when you have that going on, the court is not able to get to the backlog that it's seeing in the criminal cases. So I find this slide interesting, but I don't have exactly the answer why. I only have, from my experience over a long time, when I see this, it suggests something. The added family cases, this is just a graphic way of in total seeing, what went on quarter to quarter, first quarter, half year, three-quarter, and full year comparing fiscal year 23 to fiscal year 24. Some people like to look at graphs more than they like to look at the numbers, but you can see that overall, that docket is, when you go over a full year, because of the volume of the various chins cases has gone down, but for termination of parental rights. This is it's a graphic way of looking at fiscal year 24 compared to 25. In fiscal year 24, we saw this big increase in felonies, almost 8%. Comparing quarter to quarter, that first quarter 24 to the first quarter of 25, misdemeanors are actually down from fiscal year 24 to 25. Felonies were up, and other cases went through the roof. Probation violations and the like. And overall, it aggregates to the first quarter, seeing a 5.9% increase in the first quarter overall caseload. So again, this is that back pressure that you're seeing on the backlog that hasn't hit the backlog yet because they're new cases, but they're coming. So when we come back next year and we say, where are we? And you wonder, well, why are we not making more progress on the backlog than you would hope. It's not just what the backlog is, because the backlog's not static. The backlog's constantly being fed by whatever's going on before it ever becomes a backlog, right? This is every county for fiscal year 24. We already talked about the increases that we saw, and with the huge increases in the other cases, which are primarily probation violations. I put this in here because I know legislators like to check out their own county and see how they're doing. And you can see where some have had decreases in caseload. Grand Isle should be very happy. Memorial County has seen a decrease in caseload, but a lot of other counties, Bennington is up, when Chittenden County is up, that's a problem because it's 39% of the total state caseload. And then you've got those, what I consider like this, Chittenden's a whole world in and of itself. Okay, take Chittenden out of everything, but look at Orleans, look at Rutland, look at Washington, Wyndham. Those will tell you a story about Bennington is another one, kind of those, all of the counties are not exactly the same, but sort of mid-range sort of caseloads. All of those are telling you the story of where the caseload is, going up. And you're seeing double-digit plus in many of those. Windsor's doing okay with their essentially flat with a 1.4% decrease in their caseload. But if you want to check out your particular county, I'll have this sent over and you can take a look at it. This is just another way of looking at the data that I've been talking about, and I highlighted the double-digit increase counties that without the breakdown of felony and misdemeanor. You just want to look at it in gross terms. Yes, that's all, folks. In any event, there's another piece of this that I think I want to talk about, which is very concerning. It's been growing over a period of the last 10 years. It's become more acute in the last 5 years. We have a fair amount of resources deployed, but we have a smaller number of people doing more work. We have, and whether it's in the staff system or the contract system, we actually have less contractors and less staff doing more work because there aren't enough lawyers to actually take the work. In the last year, have had openings that have they're sitting there, we're advertising, we don't even get applicants. And I'm not talking about those that are contractors who they don't get benefits, they don't get, none of their overhead is covered. These are the conflict contractors, so to speak, or the serious felony units or the like. I'm talking about fully benefited staff positions in Rutland, in Chittenden, in Franklin County, in the Prisoners' Rights Office. I've had positions open that have sat open anywhere from a year to 18 months where they don't even apply. And the lawyers, there are not, I don't know, it's two things. Number one, the demographic of lawyers is shrinking significantly. The bar is aging. When I came in, I'm going to be 62 years old this year. I came in during the kind of boom of lawyers coming into the state of Vermont that came in the late 80s through the 90s. That number is falling like a stone. And the vast majority of lawyers are now my age. They're not 20s, 30s, 40s. And we aren't replacing them. So we get almost no lawyers from in the entire state, we get almost no lawyers from Vermont Law School. They're not even worth talking about. You're talking literally single digit number of lawyers applying for jobs in Vermont from Vermont Law School, even seeking to be licensed in Vermont from Vermont Law School. Where people are coming in is from out of state. When they come in from out of state, it's one of two ways. Number one, usually is they've practiced for 5 years and they're coming to waive in, having practiced for a period of time in another jurisdiction. Those are not the people who generally want to do public defense work because they have some establishment in their career. Tends to be that public defenders are a young person's game. You know, you get the 30-year-olds. You know, you don't get the 40-plus-year-olds applying to be public defenders. And the other thing we have is some who are coming in within their first couple of years. This is a smaller, much smaller amount. We have the uniform bar exam, right? That some number of states have adopted. Vermont did some number of years ago. I didn't know at the time. We had a conference on this. Chief Justice came and talked. We were all there. I think Barry was there. I didn't know what I didn't know how it was going to cut. Were we going to get people from out of state, or is it going to make people who are in state, like from VLS, would they take the UBE, uniform bar exam, and then they go somewhere else because it transfers the other way just as easy as it transfers this way? We haven't seen any benefit from that to speak of. The people we're getting are the people who are more established in their career coming into the state. I've been on the Vermont Bar Association Board of Bar Managers for over 30 years. I was president a long, long time ago, 20-something years ago. But the difference is marked in the way that demographic of the bar is presenting itself to us. Why is all this important? Because we can't fill positions to do the work that needs to be done to address the backlog in particular counties. What I've been doing a lot of is moving deck chairs. I'm transferring people from Rutland to go to Chittenden when they have an opening. I'm transferring people, from other, from central office to Bennington or whatever the case may be, to try to fill openings to kind of just keep your kind of fingers in the holes as it's leaking on you. But we aren't getting new applicants. We've had a little reprieve in the last couple of months because the New Hampshire public defense system right now is in a tailspin, and and many are abandoning New Hampshire. And I've been able to hire 3 public defenders who have been public defenders for a while out of New Hampshire, but I have 7 openings. So I got 3. Now I'm down to 4 openings. Anybody here from Franklin County? I have two openings up there that I haven't been able to fill in months and months and months and months. Hasn't been a year yet. On the one hand, we're very proud that Mary Kay Lanther became a federal judge. Trying to fill a Rutland opening. Oh my God. It's like, I'm just thankful that the people in Lamoille County are hanging in there because I've never been able to actually fill a position there. I just have to transfer somebody and give them more money. Though I can't get anybody ever applying. We're also in a position now where our Orleans County primary public defense contractor gave notice to me last June that they were not going to renew that contract. Some people have expressed interest, but as of right now, nobody has stepped up. So I may be faced within the next month with saying I have to establish a staff office up there instead of a contract office, which it has always been for, literally 30 plus, however long the public defense system has been around since 1972. That's how long there's been a contract office in Orleans County. And that may have to be a staff office, but I don't know how I'm going to hire anybody up there. It is very difficult to hire people, and you see this in many states. New Hampshire has the same problem. Maine has a different thing going on because they have a pseudo public defense system, but rural public defense systems, legal aid offices have extraordinary difficulty hiring anybody. And this all impacts backlog. So all of these things where I'm saying, I've had 2 openings in Rutland County, I've had 2 openings in Franklin County. Those places are gonna be your next hotspots in your backlog, because there are not lawyers there to do the work. I have moved contractors in to try to absorb some of that caseload temporarily, but that's a Band-Aid. Ultimately, you gotta be able to fill those positions. So when we're talking about access to justice, like this meeting, we're talking about dealing with backlogs, dealing with caseload increases. You can't forget, and I know the state's attorney's Kim left, but I know that maybe you can speak to him.
Yeah.
Do you have any trouble hiring?
Oh, absolutely.
It's impossible, and it's both sides. I think public defense might be a little less attractive to some folks, but it is hard, not hard, almost impossible in some areas to do it. And it's almost by, kind of the grace of God, me being in the position as long as I have and knowing where I could go to try to siphon off lawyers from, I hired a bunch of lawyers from Colorado at one point.
In Rutland.
I got 2 in Rutland. I had another one up in Chittenden County, and then there was another one. And yeah, 2 of them went back. Why? Because Vermont's too cold, and they came from Colorado. I'm like, come on.
It is colder.
Apparently it is. And one of the things they said, your winter lasts till like April. And apparently in Colorado, that's not the case. I didn't realize there was such a big difference in climate. But when it snows there, apparently it goes away relatively quickly, except for in the high mountains, and spring comes early. Who knew? But I thought it was gonna be perfect. And public defenders coming from a cold place, going to a cold place should be good. But that is the thing you kind of run into. And it all impacts, in the rural counties particularly, the access to justice and our ability to dig out of these backlogs. And it's a constant challenge. And it's much more acute now than it ever has been. Every now and then we add a new contractor, but it usually means I've already lost 2, and I'm trying to fill these holes. I almost, when Judge McManus became a judge, I was like, oh no. Because yeah, it's great for her, but like, how am I gonna hire in Bennington? When you create these holes, there's not a readily available line of people who want to take the job. So it's not just numbers, it's not just added caseload, it's capacity to handle that caseload. And we don't have it, and I think with, given the demographics of the bar, it's gonna get worse before it gets better. So
with that good news.
I actually, yeah. I don't know that anybody, if anybody who is other of our partners in the justice system disagree with a word I said, feel free to.
I absolutely, and we do have a bill to see, some sort of stipend situation. Ian's working on it with me, and we'll I've already touched base with you about that, but that's not the answer probably either, but maybe it will.
Well, honestly, it's not the money. It really isn't the money, because I haven't hired anybody at entry level in 5 years, maybe longer. I start them higher on the pay scale. It's not the money. So anyway.
Well, I appreciate it, and we will have you back when we actually see the governor's budget and as far as what we're going to want to do as far as advocating for appropriate resources for the criminal justice. So we're adjourned until the House Judiciary Committee adjourned until 1.